Hi, everyone. I would like to welcome you all to this first Nordic breakout session here at ECEC. I hope that you have enjoyed the event so far. And first of all, I would like to provide you with a short overview of EQS Group, which is the organizer of this event. Sorry. EQS Group was founded in 2000 in Munich and have in the recent years grown into a leading international provider in the fields of investor relation, corporate compliance, and sustainability reporting. EQS employs about 600 professionals across offices in the world's key financial market, where I, Ulrik, am leading the Nordic office from Copenhagen. So now on the ECEC, which has become a reoccurring event on the European Compliance and Ethic calendar, this year's theme is centered around whether we are living in a world forced to be good. The focus is on compliance and ethic and how the implementation of a corporate culture, which is built on transparency and integrity, creates the most important corporate capital, trust. However, an increasingly complex regulatory landscape demands more in-depth discussion about new laws as well and increased demand to reporting standard. So some word about the Nordics. The European rollout of the EU whistleblowing directive has been far slower than expected, and the bulk of member states missed the transposition deadline, which were ultimo 2021. Denmark was actually the first country in the EU to implement the directive with this new law on beskyttelse af whistleblower. Sweden had then followed with the gennemførende af whistleblower-direktiv, sorry for the accent, which had its deadline roughly 3 months ago. The process has not moved as quickly in Finland, but progress have indeed been made in recent weeks, and a draft law has now been issued that is broader in the scope than the minimum requirement of the directive. So the transposition is one step closer. While not being an EU member, Norway has a strong whistleblowing protection through the Norwegian Working Environment Act of 2007, which was last updated January 2020. It is different from the EU whistleblowing directive in the way that extended company stakeholders are not afforded protection, such as former employees, family members, job seekers, etc. The EU directive may eventually be transposed in Norway if the EEA EFTA states classified as EEA relevant. It is now essential for compliance officers and company heads in the Nordics, as well in Europe, to be aware of the legal requirement of the EU whistleblowing directive in order to avoid any possible sanction for their organization. So a few key points to consider are that all organizations with 50 or more employees are affected. Functioning whistleblowing channels must be created. Retaliation is prohibited. Cases must be handled impartially. Whistleblowers must be protected, and feedback has to be provided at set intervals. ESG has been mentioned quite a lot on the ECEC already, and embracing the G for governance is going to be crucial in satisfying the new regulatory requirements. Most companies are already familiar with governance, and that is actually a major benefit when it comes to rolling out an effective compliance framework. While the enacted legislation in Denmark and Sweden, along with the forthcoming transposition in Finland, represent a huge leap for the whistleblower's right, the law nevertheless still present a major challenge for compliance officers across the region. And that is what we are here today to discuss. I am delighted to hand over the floor to Antti Aalto from KPMG in Finland, who is the head of legal compliance, who will get our first session started on the EU whistleblowing directive transposition, learnings from Denmark and Sweden, and the upcoming whistleblower protection law in Finland. So, Antti, please.
Thank you, Ulrik. Pleasure to be here, and I'm glad to report that also in Helsinki we have sunshine to celebrate the occasion instead of the steady rain that we've been having during the past 24 hours. So welcome indeed. Um, can we have the slideshow on? Thank you, and move on to the next slide, please, if you can. Or is that in my command? Well, basically, what I seek to do is to bring you up to speed as regards the directive interpretation and the national transposition in Finland of the law. So we have a draft law in place at the parliament since 2 weeks, basically. And what we see there is that the Finnish interpretation is pretty closely following those interpretations and evidence from the directive itself. But we do have our peculiarities as regards to the transposition. Just to put you on the sort of scale of things, the Finnish government proposition for whistleblower protection law contains 300 pages. In comparison, the German proposition contains 120 pages. So the Finnish proposition is rather detailed. And what we'll do during the presentation is try to make a connection with the what is the whistleblower regime actually trying to establish, and that is to tie it to the governance requirements of organizations. And moving on, please. What I'd like to bring to your attention or into your consideration is the question of how to interpret the national legislations. We have rather different interpretations in Denmark and in Sweden already. Another sort of line of interpreting what are the minimum requirements of the directive that needs to be implemented nationally. The Germany is a good example on that. Germany actually calls in as reportable items any transgression against German national law or regulation as compared to the directive. And what I want to point out at this stage is that in international comparison, the European Union whistleblower protection regime is only the second in the world that is considered to be protective towards the whistleblower. And the first one, of course, is that of the United States of America. So what we have from European and especially from Nordic point of view is quite a quantum leap in requirements attached to the process of whistleblowing and whistleblower protection and the management of whistleblowers within any given organization. And moving on. What we have in the general regime of whistleblower European Union directive is the idea that basically the employer units or companies are incentivized to provide a credible and effective procedure to sound concerns from a protected position. And that's probably due to a study that was commissioned by the European Commission in 2017, which concluded that 3 out of 4 Europeans that had observed wrongdoings in their workplace dare not report the wrongdoings due to fear of retaliation. 3 out of before did not report out of fear of retaliation. And what that means is basically the management of the company or the employer organization is deprived of information which they basically need in order to discharge their duties as the directors. So here, in my opinion, is the most compelling reason to have a proper functioning protecting whistleblower regime in your company. Your management's ability to discharge their duties depends on the credibility and functioning of the whistleblower system and process. And there are many details in this, and I will jump through this, just touching on the directive and the Finnish proposed law. And the directive and the Finnish regimes are similar in the sense that there's a 3-month period of precedence or even privilege for the company to have the suspicion, i.e. the whistleblower information, and to address that if the company-owned whistleblowing system and process is up to par with the directive requirements. And that's a big advantage as compared to not having such a proper system and organization, as if you don't have that, you lose the privilege to that information. And the informant can go to the public channels at the company's protection to blow the whistle. Hence, the company needs to still protect the whistleblower, even though the management does not have the information and hence cannot act on that information. So a very strong incentive to actually have a proper system and organization in place and to document it as required in directive and in national transpositions of it. The employer's obligations, the Finnish law is rather detailed in that sense, and I shall not bother you with too much detail, but these detailed actions that you can read are actually quite illustrative of what is actually stated, not so clearly, I admit, in the directive. The directive itself has been sort of blamed of being very difficult to interpret, and I'm unable to disagree with that blemish. But we've been doing this for about 3 years now, 4 years almost, and I think we've got a reasonably clear picture of what are the requirements of the directive, and hence what should the national legislation also contain. An interesting point in the sense of why the European Union directive is considered to be protective towards the whistleblower and hence generative of information is the extent of protection it offers to the whistleblower. And I'd like to say that the protection almost reaches but never touches the United States law principle of punitive damages, i.e. paying extra, not only the damages, but a compensation for the person being mistreated in one way or the other. But in this point, it is quite, in my opinion, important to notice that it does not pay punitive damages. So it's not a get-rich scheme. Another thing is, which I think most of you are familiar, is the reverse burden of proof. So if something bad happens to a whistleblower, the company is liable to prove that it was not a revenge for the whistleblower. And if that cannot be done, the company is liable just as well as if the whistleblower goes to public channel. We have broken the requirements into 6 sort of thoughts or themes, and we probably just jump on the sort of headline level. And first and most difficult of the requirements is to create a technically administratively credible internal reporting channel. The difficulty does not arise only from the fact that the requirements of the directive are not crystal clear, to put it mildly, but require a fair bit of interpretation. But after that, you need to be in a position to clearly communicate the idea that your system is credible to your employees and other entitled constituencies, such as trainees and job applicants and hired hands even. The technical issues are rather difficult, and I think we have our host has showed some progress in that sense, that the EGS systems are quite satisfactory in the sense with regard to the directive requirements. Last summer, we had a bit of a discussion with reference to the Danish implementation and the Swedish implementation also, as European Commission stated that the channels should be arranged on a national or even employee level as organizations, and not only channels of a corporation. And my understanding that Commission probably has a different set of directive or different wording of directive than I have, because I haven't read from the directive anything to the effect of a requirement of having a separate channel for each company or separate channel in each sovereign state within the European Union. So it is very good of Commission to communicate an idea like this. However, we probably need to put a bit of salt on top of that opinion, or whether or not it is indeed based on directive or not. Now, the Finnish national interpretation or transposition does allow for a centralized system and centralized process. However, we need to address several other issues that arise with that choice. As to what should be allowed, directive is quite clear, even though it is difficult to read, and even the Finnish national law proposal is quite clear and still contains a bit of a misspelling error in the text. Written announcement on technical platform is the way to go. One of the most curious, in my opinion, Finnish national requirements is that the employer, so the party who is liable to arrange for the channel, is liable for the technical progress of the channel and the organizational progress of the channel of the organization. The latter is not quite surprising, but the actual due diligence that employer needs to put to work prior to acquiring a SaaS system for the whistleblowing is not exactly cheap or easy. So there probably attention to the self-clearances of the various SaaS providers. The resolution body comes from the directive, and this also varies from country to country whether or not you have two-layered system and process or one-layer system and process. The directive itself says it's two-layered. So there's a decisional level and there's an operational level. And that's quite understandable given the actual meaning of the system. The very basic ideas of the directive, then the whistleblower should be answered to in 7 days. Nothing new there, and the feedback should be sent within 3 months of the report being received. And the only thing about the report is what can you disclose in the report for it to be sufficient. That's a topic of a separate lesson, so we'll get there some other day. One of the sort of, as I hinted in the just a couple of minutes ago, the difficult thing is to how to create the credibility and trustworthiness of the system and process amongst your employees. This basically builds on two blocks. First, you have to have the administrational and technical prowess, and you have to have the ability to communicate it. And regardless of the system, not all systems are easily communicatable as trustworthy and reliable. On labor legislation requirements, I think that the Finnish approach, being very precise, is an easy one in the sense that it sets out the process pretty well, as compared to what was contained in the directive. So in that sense, I think the Finnish legislation is probably even useful in practical terms. And the GDPR issues, don't get me started on those. I think we are going to skip this, as the GDPR is a bit of a hot topic. I think it's sufficient to say that by Finnish standards and by European Union standards, usually the data privacy impact assessment is the year prior to implementation or major change of whistleblower system, as is the policy on how you deal with the sensitive or especially sensitive information that is likely to be found in the whistleblower system. And this is a big deviation from the data that you usually come by and process. The data that is processed in the whistleblower system is likely to contain suspicion of wrongdoing, even crime. It is likely to be connected with an identifiable person. Hence, it is especially sensitive personal information, and it needs to be protected with special care. One thing that the lawyers usually come up with is, okay, what do we want to as pieces of information into the channel? And these are the colorful balls. And I couldn't care less, because what's on the right bottom corner in my screen is the reason why the board of directors of each European company should probably call to the reliable and trustworthy the whistleblower channel all discretions and misdemeanors that happen in the context of work life. That is because it's their duty and their way of actually discharging their liability as directors. They need to get access to that information, and hence they need to ask for it. And if they don't, someone will ask them, why exactly did you not want information on other items that the European Union directive enumerated breaches in your channel? And that is very, very difficult thing to explain, I guess. Now, to the governance issues, I will just briefly touch on this. This is the Finnish Companies Act, basically explained in 5 bullets. And basically, what it states is that, okay, you need to find out. If you didn't find out but tried, you are okay. But if you didn't try to find out through having an appropriate whistleblower system, you have a lot of explaining to do. Finally, a brief glimpse into Finnish versus US system and the European Union whistleblower system. What we have here is the hallmarks of appropriate compliance management of United States Ministry of Justice. From this is that in principle and in practice on many levels, requirements are the same. However, the US process and system is very different. Topic for quite a while now is the ISO 37301 standard. So the management or governance standard is the new one from last year. And again, we take a look at the requirements of appropriate governance and management, and the same topics and same doings pop up. So I conclude by stating that, okay, now we are pretty much aligned as regards global and local requirements. And I would like to hand over to my dear colleague, Erik Lagerlöf. He's not only a KPMG colleague, but a fellow at Cambridge and adjunct professor in Stockholm School of Economics. So whatever thoughts you may have had before and didn't dare to ask. After Erik, I think is your moment. So, can we have Erik on the stage, please?
Hello. Hi. I hope that everybody can hear me, and I will see if I can get up my slides up. There we are. Hold on. There. I hope you can now all see this. I am watching my slides, and I hope that you can also see the slides. What I thought I might do is to put whistleblowing into context, and particularly in an ESG context. And I realize that we're on short on time, so I will run through this rather briefly. The agenda I had prepared was first to just merely flash out ESG obligations that you all now have to consider. Some of them are in force, some of them are expected to enter into force rather shortly, and some of them are still being considered within the EU institutions. I will then move on just briefly to the whistleblower legislation. That is something I will touch on only very briefly, given Antti's brilliant presentation before me. And then just briefly put whistleblowing into an ESG context, and also perhaps suggests a few steps that you may want to consider in your organization. Now, you are well aware of the extensive ESG requirements that now exist and that are waiting to enter into force. I have no intention at all to go through all these instruments, but this is just to give you an idea by way of showing a picture of the different instruments available. Some of them, as I said, are in force now. For example, the notorious taxonomy regulation. Some of them are expected to enter into force, and some of them are still being discussed. And of course, one very controversial instrument that we're waiting for is the Corporate Sustainability Due Diligence Directive that we'll hear about later. That will, in my view at least, enforce rather extensive obligations that, at least in a Swedish perspective, is quite unheard of. On the new whistleblowing rules, I could only say this about the Swedish legislation. It actually did enter into force on the 17th of December of last year, as it should, but it didn't start to apply before mid-July of this year. It is much broader in scope than the directive. The directive obviously focuses on breaches of EU rules, whereas the Swedish legislation also focuses on national law, provided they occur in a work-related context. I think what I would like to emphasize is the discrepancy that may exist between the directive and the Swedish national legislation. Having gone through the Swedish legislation, I think there are a few issues with that, and it is not entirely, in my view, it has not entirely implemented the directive correctly. And my advice would certainly be that you very carefully read through the obligations of the directive and compare those with the Swedish national legislation. There are a few provisions that to me seem contrary to the directive. And what happens then, well, as Antti mentioned, I believe, is that, of course, the directive takes precedence, given the primacy of EU law over national law. So I think that is an important point to remember going forward, that you cannot only consider the national legislation, you will also have to look at the directive in parallel. And some of the key obligations, I will not go through that, but just to mention that there are sanctions available in the Swedish national legislation if you would not implement the directive correctly, or sorry, if you would breach some of the obligations that are now available both in national legislation and in the directive. And in particular, you may have to pay rather heavy damages. Putting whistleblowing in an ESG context, again, only very briefly, I think you all realize that there are extensive ESG requirements to consider. But I think the whistleblowing legislation must be considered as a tool for you regarding the implementation of these tough new ESG requirements. I think whistleblowers must be considered as the first line of defense against wrongdoing. It is there for you to, if you handle it correctly, the whistleblower will assist you in preventing and indeed correcting an irregularity before it escalates, before it becomes more of a problem than it actually already is. So dealt with correctly, I think the whistleblower and the whistleblowing legislation is there to assist you when you implement the tough new ESG requirements. And it's meant to build a culture where complaints and misconduct are managed in a secure and confidential manner. I think that is the appropriate way to look at the new legislation, rather than some rather difficult new tool that you must all now have to consider. But it's there, or if used or handled properly, it is there to assist you in your organization. Just a few steps to consider. Well, obviously, I think you would have to comply with the regulations, but there's one point in particular that I would like to stress, is that given that the directive provides minimum standards, meaning that member states are able to go further, which indeed has happened in Sweden, you will all have to, if you have operations ongoing in different EU member states, it's not sufficient to only consider one member state and the legislation that is enforced there, or indeed only the directive. You will still have to look at all the different member states that you have operations in order to understand the obligations of each and every member state. You should also, or you may want to consider whistleblowing training, in particular to middle management, who are normally the first line of recipients for these sort of complaints. You may want to also consider certain internal reporting campaigns. You may also want to conduct risk assessments, reviews of your ESG policies in light of whistleblowing obligations, and see if they are aligned and if they function well together. That was what I've done now is just whip through the available ESG requirements, and to put that into context with the new whistleblowing requirements in the whistleblowing directive, but also in Swedish and also in other member state national legislations, to provide context, perhaps, I understand only very briefly, but provide a context in which the new whistleblowing tool is meant to operate. So I think I'm well aware of the time. I think I will stop there and hand over to the panel. Thank you.